Thank you for your support. Sorry, I was engaged in something else, so I'm late. Now we have to elect the deputy chairman. We have a nomination. The deputy chairman. We have Mr. Chao Siu-chung nominating Mr. Dennis Leung, and the nomination is seconded by Dr. Frankie Yan. According to paragraph 8D of Appendix 4 to the House Rules, the committee may decide whether it's necessary to elect a deputy chairman if any valid nomination is received. So do we want to elect the deputy chairman? Agreed. And we all support Mr. Dennis Leung to be the deputy chairman, right? I declare that Mr. Dennis Leung is elected as the Deputy Chairman of the Bills Committee on Employment Amendment Bill 2025. Let's carry on with the meeting. Let us first invite government representatives to join us. Welcome on the Secretary and his team. Let us first invite the Undersecretary to walk us through the bill. Thank you, Madam Chair. Thank you for joining the Bills Committee to scrutinize this Employment Amendment Bill 2025. The bill seeks to amend the working hours threshold of the continuous contract requirement under the Employment Ordinance to make it easier for employees to meet the requirement and enjoy comprehensive rights and benefits. The continuous contract requirement has been in existence since the enactment of the ordinance in 1968, with the objective of establishing the legal obligation of employers to provide employment benefits to employees who provide stable and a considerable level of service. Under the existing provisions, an employee is considered to be employed under a continuous contract if he or she has been employed by the same employer for a continuous period of 4 weeks or more and has worked for 18 hours or more each week, commonly known as the 4-18 rule. Employees must be employed under a continuous contract in order to be entitled to a wide range of employment benefits, such as statutory holiday pay, pay annual leave, sickness allowance, statutory maternity leave, and long service pay, and so on. Otherwise, they are only entitled to some of the basic protections, such as payment of wages, restriction on wage deduction. According to the existing provisions, if an employee works less than 18 hours in a week, the continuity of his period of employment under the continuous contract will be deemed broken. The bill proposes to lower the weekly working hours threshold of continuous contract from 18 hours to 17 hours. It also provides an alternative of using the aggregate working hours in 4 weeks as a counting unit, in which a week with less than 17 working hours will be counted towards a continuous employment period if the sum of the working hours of that week and those of the 3 weeks immediately preceding that week reaches 68 hours. This is to provide flexibility, and the Labor Advisory Board reached a consensus on this proposal. Other provisions of the Employment Ordinance will continue to operate as they currently do. The existing eligibility criteria for the various benefits will remain unchanged. Upon passage of the bill by LegCo, the Amendment Ordinance will come into operation on the first Sunday of the 6th month after its Gazetted to allow employers and employees sufficient time to prepare for the commencement. I ask members to support this bill so that our employees can benefit as early as possible. Now, members may raise questions on the policy matters concerning this bill. 6 members have asked to speak. They are Mr. Kwok Wai-keung, Mr. Lam Chun-sing, Mr. Michael Luke, Dr. Frankie Yan, Mr. Chao Siu-chung, and Ms. Doreen Kong. 6 members, 4 minutes for each member. Mr. Kwok. Thank you, Madam Chair. We have called for the 418 requirement for years. Those who received calls for betting, if they worked for less than 18 hours per week, they would not be entitled to the benefits under the continuous contract. This is a significant amendment. As mentioned, this ordinance has been enacted for 1968. It's been about half a century. This is an important amendment for employees. In the past, working hours were counted per week. Now we can use the aggregate working hours in 4 weeks as a counting unit, in which a week with less than 17 working hours will be counted towards a continuous employment period. So this will offer employees more protection. In the past, if we were to add 18 hours per week, that's 72 hours for 4 weeks. Now it's only 68 hours under the proposal. And we are all for this proposal, even though it might be just a small step forward. We may not be able to fully avoid employers who want to circumvent the arrangement. Say, for example, a worker works less than 68 hours within a month. The employer may be able to circumvent the arrangement, but the cost behind would be great. So there's no incentives for employers to circumvent the arrangement unless the employer is not short of staff. Therefore, the FTU fully supports this amendment, and we hope the amendment will be passed as early as possible. We also hope that the relevant government departments will review the ordinance where appropriate. We hope that there will be regular reviews on the ordinance instead of waiting for another half a century to carry out the review. We hope the government will take into consideration the existing labor market and offer more protection. So you're just expressing your support. Yes, this is a consensus reached by the Labor Advisory Board. So we don't have particular views on the proposed amendment. Thank you. Mr. Lam Chun-sing. As said by Mr. Kwok Wai-keung, we are plugging a loophole here through this amendment. In the past, people have to work for 17 hours every week for 4 weeks. And for those who work for example, 67 hours every month, I think this amendment won't pose any significant changes to them. Through this amendment, we want to take care of those who work for a few hundred hours per month. We want to prevent any employers from offering benefits to these employees who work long hours. We hope this amendment can plug the loophole. However, can we fully plug the loophole? How confident is the government that it can fully plug the loophole? For example, a worker may work for 200 hours a month, and for the next month, 67 hours, and for the third month, another 200 hours. This worker may not be deemed as an employee under the continuous contract. However, this employee works for long hours. For such cases, is there anything that the Labor Department can do to offer help? The Labor Department used to say that even if you terminate the contract and sign a new contract with the employee, it would not be allowed by, for example, the court. According to your paper, over 10,000 people would benefit from this amendment. There might be extreme cases in which workers may not be able to benefit even through this proposed amendment. And what will the Labor Department do Some security guards, for example, they work 17 hours for the 4th week and they work over 100 hours within a month. After the amendment, these security guards will be able to benefit. But if the employer reduces their working hours after the amendment, would this be regarded as a unilateral change on the employment contract? And how will the Labor Department deal with this?
Can I defer to the Labor Department to respond to the several scenarios? Thank you, Chair, and thank you, Mr. Lam, for your question. Members have mentioned that this round of amendment seeks to lower the weekly working hours threshold, and at the same time, we are also making a general relaxation to the number of working hours so that employees who used to work less than 18 hours in a week in the past would still be able to enjoy the benefits, because in the past they would not be able to meet the continuous contract requirement. We hope to deal with that kind of situation. And members have also referred to employers trying to circumvent the law. It's not the case that they will not be able to circumvent the law, but the costs will be higher. I agree with that. Members refer to some special cases in which employees working long working hours will still not be able to meet with the continuous contract requirement. There might be all sorts of scenarios. Yet, there will be a number of cases which will not be able to meet with the requirement out under the old framework, but will be able to meet the requirement under the new framework. So in some cases, we will not be looking just at the figures. We'll be looking at the actual circumstances of the cases. The member referred to the cessation of employment relationship, and then the employee is rehired again, and also whether there will be a change of working hours, making an employee unable to meet with the relevant requirement. Would that be a unilateral revision of employment contract? This may be possible. But we have to be mindful about the actual circumstances of each case. If employees believe that the benefits are undermined because of such revision on the part of the employers, they can approach our Labor Relations Division. We'll try to understand the cases and provide the relevant advice to them. Mr. Michael Look. Thank you, Chair. The amendment is about amending the definition of continuous contract, and this concept was first floated in 1968, and of course the labor sector is fully supportive of changing the requirement for 418 to 468 requirement. Mr. Hao Kai-ming used to be a frontline worker, and I believe that he has received a number of inquiries in which a lot of employees don't understand what is about continuous contract, and they don't know that if they meet with the continuous contract requirement, they are entitled to all sorts of benefits, including long service payment, maternity leave, etc., etc. So this amendment is revising the requirement to 468. What kind of a publicity campaign will the government mount to drive home the message? Some daily paid workers may meet with the continuous contract requirement, but they don't know about it, and at the end they might have to chase after the employees at one go. So what kind of publicity plans does the administration have? Undersecretary, can I defer to the Labor Department to talk about the publicity campaign upon the passage of the bill? Thank you, Mr. Look, for your question. In terms of publicity and education, we will mount an extensive campaign. Like what Mr. Look said, 418 requirement has been in existence for several decades. Now we are proposing a revision, and not many legal provisions in the law will be amended, but there is indeed a fundamental change in the arrangement. So we hope to enable members of the public to understand what we are revising. For part-time workers and casual workers, they come in all sorts of formats or job types, and even employers couldn't tell the differentiation. And some may be employed as casual workers or some part-time workers, and some of them may not meet with the continuous contract requirement. So we will drive home the message very clear. This is not the way to look at it. As long as they meet with the continuous contract requirement under the law, no matter what the how the workers are called, part-time or otherwise, they will be covered under the law as long as they meet with the continuous contract requirement. In our tripartite consultative committee, in the Human Resources Managers Clubs, we will do publicity. We will also work through the labor unions to tell the workers clearly what the changes are, what areas they should pay particular attention to. And we would also work with the chambers of commerce to do publicity. Employers likewise need to know about the change. Going forward, we would step up publicity and education. They would also be made aware of the calculation method. We will come up with some tools, so to speak, to facilitate employers and employees to calculate the number of working hours to see whether they meet with the new continuous contract requirement. Thank you, Mr. Frankie Ngan. I have two questions. First, if there are 2 to 3 weeks under which less than 17 hours are worked, does it mean that these employees will not meet the requirement? And then you talked about the promotion efforts. So mostly grassroots workers work on the continuous contract. They may not get access to a lot of publicity channels. How are you going to publicize among them? Like what I said at the outset, 17 hours per week is just one way of calculating the number of work hours. If this fails, he can resort to the aggregate 4-week aggregate working hours. As long as they work 68 hours over a 4-week period, they will be entitled to the benefits under continuous contract. We know that a lot more grassroots workers will benefit under the 468 requirements. Like what the Labor Department said, we'll work through chambers of commerce and labor unions, and we'll come up with two so that they can better understand the new requirement. We would make the best use of our resources to do publicity to enhance the awareness of the workers on these new requirements. Any further follow-up? Can the administration consider to go to the workplaces of the grassroots workers and distribute pamphlets, they don't go online. And they might not approach the labor unions very frequently, and labor unions may not be able to spot them. So can you really reach out to them in a more directly and drive home the message? Yes, thank you very much for your comment. We will go to the workplaces of the workers and distribute leaflets to make them aware of the changes. Mr. Chao Chiu-chung, thank you, Chair. The definition of continuous contract is very important in terms of offering employees benefits. This is a fundamental for offering employee benefits. As long as they meet the continuous contract requirement, they are entitled to the benefits. Well, the definition of continuous contract has been there for some 30 years, and no revision has been made so far. And we've been discussing the revision for some 10 years, and I welcome the LAB reaching a consensus on this, and I'm all for the revision. Like what the administration said, we aim to plug the loophole. What kind of loophole is that? As pointed out in the paper, employees may work long working hours, but employers may willfully lower the working hours in a certain week to below the threshold, then the continuity may be broken. And this loophole has been taken advantage by employers to circumvent the law. And the obvious example is this. Well, in the first 3 weeks, they may work very long working hours, but in the fourth week, less than 18 hours. So the continuity is broken. Now we are proposing this revision. Can we fully plug the loophole? Like what Mr. Lam Chun-san said, the loophole cannot be fully plugged. Well, maybe like the example he cited, an employee may work 200 hours in 1 month and then 67 hours in another month and then again 200 hours in another month. So the continuity is broken then. But if employers are to do that, the administrative costs may be high. But then there is another way where the administration costs may be lower. My colleagues has helped me come up with this table. Let's take a look at this table. Now, upon the revision of the definition, if the roster is like this, first week's over 72 hours, 72 hours in the first week, and then second, third, and fourth week, together, the working hours is 67 hours. So 72 plus 67 hours. So for the 1 month, he has worked 139 hours. For a full-time worker, 5 days times 8 hours, around 160 hours per month. And then for this employee, 140 hours per month. And then on the fifth week, 0 working hours. For this case, the continuity is broken. He will not be able to meet with the 648 requirement. And he's actually working 139 hours per month. And so the loophole is still there. So if the employer has to make use of this loophole, his administration costs may rise. But anyway, the loophole still exists. So my question for the administration is this. After the new requirement is implemented, would you be regularly monitoring the labor market to ascertain whether such cases that I mentioned will increase in number? And if this is indeed the case, will you have managed any measures to make amends? Would you continuously monitor the situation and review from time to time the law? Thank you, Mr. Chow, for your very detailed thinking to come up with all these different scenarios. For any policy, there is a line to be drawn, and loopholes may exist. For those who are just under the law, then there might be a loophole and the requirement cannot be met. The same, say, goes for the working family allowance and so on and so forth. And for the under the revision, we're talking about an aggregate working hours of 68 hours. Compared to the past, is even more difficult. It's more difficult to take advantage of the loophole. I used to work part-time. I worked less than 17 hours per week, so my continuity was broken. But upon the revision, we are looking at an aggregate of 4 weeks, so the preceding week's number of working hours will be taken into account. And if a company is making, well, it's trying to take advantage of the loopholes to try to gain an advantage, well, then I'll be worried about the operating condition of this company. I don't think this is a good business practice.
Will you monitor the labor market? Mr. Leung. I thank Mr. Chow for the questions. Members have said that we haven't introduced any amendments for decades. Now that we are implementing a change, will there be any impacts on the labor market? Well, we will continue to monitor the situation. Under the labor revisions divisions, we may receive more cases about whether the requirement of the new continuous contract is met. We may get labor dispute cases or claims because of the new requirement. There may be employers who try to circumvent the new arrangement and avoid offering employment benefits to workers. However, we believe that most of the employers will stick to the new arrangement as they come up with the rosters. As said, whenever we try to draw a line, there will be people who fall under the requirement. We, however, see that over 90% of the employees are above the line, that is, they are meeting the requirement. We think that under the new arrangement, less than 90% of the people will fail to meet the requirement, because even under the current arrangement, 90% of the employees are able to meet the criteria. Therefore, we think that with the amendment, even there won't be a huge number of employees who fail to meet the requirement, but we will continue to monitor the situation. Ms. Doreen Kong. Madam Chair, I support this bill. The government is proposing the 468 requirement. I think this is a minimum protection for workers. The government is taking a step here. Now we will see various job types in Hong Kong. There are part-timers and slashers. According to statistics, the new arrangement will benefit 11,400 people. However, there will be a lot of part-timers who will not be entitled to the benefits under the new arrangement. Will the government review the arrangement so that the new arrangement will benefit those who work different jobs. Now, according to the paper, the 468 requirement will bring the cost up by $150 million for employees in terms of the cost. Will there be any support for SMEs in Hong Kong so that they can adapt and adjust to the new arrangement? Undersecretary. Now, in terms of new employment modes, we discussed that at the panel on manpower. Within this year, we will make announcements in terms of how we can better protect workers under different types of jobs. This continuous contract mode is a major pillar for employment relations. We want to have more certainties for employers and employees. As for new modes of employment, we will carry out relevant review and will make the announcement within this year. As for the other questions, I'll invite Mr. Liang to tell you more. Assistant Commissioner, I thank Ms. Kong for the questions. Ms. Kong just now mentioned about 11,400 people who will benefit after the implementation of these legislative amendment. This is a rough figure. This is just an estimate. These 11,000 people, well, we came up with this figure because we assume that, say, everything remains unchanged, how many people who currently do not meet the 418 requirement will be able to meet the future 468 requirement. There may be changes to the behavior of employers and employees. For example, we take into consideration how many people or workers employers will hire after the new arrangement is implemented. Will there be people who join the workforce because of the revision to the ordinance? These people may not be working now, but they may join the workforce after the amendment is passed. We haven't been able to have a very clear estimate about this, but we do want to keep more statistics in this regard in the future. We want to see what changes will there be to the employer and employee relations, as well as the future trend after the amendment is implemented. Madam Chair, the cost will account for the total cost for businesses of 0.02%. This is a very small percentage, so we currently don't have any plans to subsidize employers in this regard. Now it's my turn. I very much welcome this amendment. There were women from the grassroots complaining to me about the 418 requirements because a lot of them, they have to take care of their children at home, and so they weren't able to meet the 418 requirement. My first suggestion is that we have to step up publicity for working women. Also, can you tell us what kind of workers will benefit under this arrangement? What industry will benefit? Mr. Liang? In terms of publicity, we will step up promotion for the grassroots. As for working women, we'll see how or what kind of organizations we can collaborate with for the publicity campaign. There are women associations in all 18 districts, and these organizations, they reach out to many grassroots women. For example, those in Kwai Chung or in Kowloon, they have more contacts with grassroots women. what kind of industries or what kind of workers will be able to benefit from this arrangement, say the F&B industry? Well, according to the survey done by the Census and Statistics Department, we see that some workers under certain industries, they aren't able to benefit from the current 418 requirement because of the nature of their work. And for those who are in the accommodation industry or catering industry, there are more people under non-continuous contract. So positively speaking, we hope that we can have more women benefiting from the new continuous contract requirement. Next, Mr. Peter Xu. With good business, good economy, we may see workers' pay go up, and that will of course be a good news. However, I think a lot of people in Hong Kong are aware of the current economic environment. The government has been stepping up workers' welfare. For example, paternity leave has gone up from 3 days to 5 days starting from 2022. The statutory leave, the number of days have increased from 12 to 17. And starting from the 1st of May, we have the abolition of the MPF offsetting arrangement. All these offer support to our workers, but we have to see whether this is good for the economic environment. Some part-timers, they are not full-time workers. In the past, they have to work 18 hours per week and for 4 weeks continuously. Now they only have to work 17 hours per week to meet the new requirement. As I said, if the economic environment is great, that would be beneficial. Some minibus drivers told us that in the past, they would get long service pay as well as annual leave and statutory holiday leave of 7 to 14 days if they worked as a full-time worker. And the employers were responsible for offering these benefits. However, for some part-timers, they don't work full-time, and will the employers have to offer the same benefits? Of course not, because the cost would be too high. Say a minibus driver is hired to work about 8 hours a day, and within 7 days they work 14 hours. And you have to give them annual leave, statutory holiday, as well as medical benefits. And this is increasing the cost for businesses. The Retail Management Association has another concern. Say in the past, full-time workers could enjoy, of course, benefits, but part-timers, they work, for example, just 1 to 2 days a week, or about 8 hours per week. If they work continuously for just a few days, they can already get the benefits under the new arrangement. So some full-timers may switch to working part-time, and this is a huge challenge and concern for the retail sector. Now I have a question. Say we have a minibus driver who work about 8.5 hours within 2 days from A company, and he will get annual leave. If at the same time he works for company B and company A is not aware of that, will the employee get double benefits and double annual leave, for example? Under Secretary, as mentioned in my opening remarks, this is about benefits for people who work long hours. For paid annual leave, normally they only get it in the second year. after they've worked for 1 whole year. For severance pay, they have to work for at least 2 years. For long service pay, they have to work for at least 5 hours in order to receive that. So say a worker only worked for about 8 hours within 2 days. And if the worker is willing to work for 2 years for the same company, then the worker deserves the benefits because he is not working as a casual worker. I understand that employers are facing certain difficulties now, but employers should not be so calculating. For maternity leave, paternity leave, and sickness allowances, a worker is entitled to that. Say a female worker only gets 2 days of sick leave every month, and she will have to work for a long time for the same employer in order to be entitled to maternity leave. A worker may now be able to meet the threshold under the new arrangement. In the past, the worker may not be able to entitled to the benefits. If that's the case, I hope employers will not be so calculating.
Can I respond? So you are asking me not to haggle over every penny with the employees. That should not be the case. We're just talking about a difference of 1 hour. We used to define these workers as casual workers. So my question is really simple. If the person works now as full-time, now he's working part-time in 2 companies, does it mean that I can get the annual leave in both companies? Will that be double benefits for him in terms of the annual leave he is entitled to? Thank you for your question, Mr. Xu. Let me explain it in another way. For any employee meeting the continuous contract requirement, be it the old requirement or the new requirement, if they have to enjoy the employee benefit, they have to meet certain conditions, including the work hours and the period of service, say 6 months or 1 year, and then also other conditions as well. Say, for example, for maternity leave, paternity leave, sick leave, they have to meet certain specific conditions plus requirement on the years of service before they are entitled to these benefits. Now we're changing the continuous contract definition. Does it mean that a lot more people will enjoy the full benefits? Oh, I think we should take a more long-term view on that. Say if an employee is now working full-time and he knows about this latest arrangement, he will then switch to a few part-time jobs. So he works now for 5 days for the same company, and now he's taking up 2 separate part-time jobs, both of which meet with the continuous contract requirement. Will he be entitled to benefits, double benefits? So the labor sector will have to see whether there is indeed some employees who would do that. Now, I believe employees would like to fetch a stable income, and the part-time job will earn him a lower salary than a full-time job, albeit he's working on 2 part-time jobs. So whether he is going to gain or lose is something up for question, because he's working for 2 employers and he signed up on 2 employment contracts. So we are looking at 2 employment contracts, so he would be entitled to employee benefits from both companies. That's true. But does it mean that he would necessarily enjoy more benefits than he working in one company? All right, I believe that you have to press for a second round because you have spent already 9 minutes. Next one, Mr. Benson. Look, thank you, Chair. The BPA believes that the relationship between the employer and employee is intertwined. And we are now changing 418 to 468. I understand that the LAB has reached this consensus after lengthy deliberations. And I understand that you have struck a balance between safeguarding employees' rights and benefits and the maintaining the affordability of employers. But the economy is not faring so well, and many companies have closed down, and large corporations are also sacking staff. And a number of trades are facing a shortage of manpower at the same time. So you are now relaxing the continuous contract requirement, and we're worried that employers will be under a lot more pressure. The 11,400 employees are to benefit, and the employers have to shoulder an extra $150 million in wage bills. But the administration said that the employers will not have to shoulder a very heavy burden. I hope that 6 months after the implementation of the new requirement, please ascertain the impact on the SMEs and micro enterprises. And if you find that they really have a hard time, then I believe you have to provide some support measures to the SMEs and micro enterprises. And then second point, the administration pointed out that the representative from the labor sector said that it will help unleash the labor force and alleviate the manpower shortage. And from the employer's perspective, if there is more manpower, then we should be very happy. So does the administration have any analysis on which sectors will benefit because of the unleashing of labor force? And do you have an estimate on the number of workers who will join the workforce? Can I defer to Mr. Leung? Thank you, Chair, and thank you, Mr. Look, for your questions. First, we will monitor upon the revision of the law, the labor ecosystems, so to speak, especially the impact on the micro enterprises and SMEs. Will there be a great impact on them? If yes, how can we provide support? And then, which sectors will be affected most, or which sectors will get the most help in terms of the extra number of workers joining the workforce? We don't have any scientific data here. Let's look at which sectors are employing employees who are not on continuous contract. Like I said, retail, accommodation, and food services are one. And we believe that for this sector, there is a high chance for us to attract people to join the workforce because they need a lot more workers who work for short working hours. Now, in terms of figures, the CNSD has a thematic household survey. They did the survey in June 2019. This is not the most updated survey. And there are 100,000 those aged 15 to 59 and 60 to 60,000 to 70,000 of them are aged 35 to 59 who are home workers, and 50 to those aged 50 to 64 are on early retirement. And the survey shows that if employers are willing to hire them, they are willing to join the force. So the ratio is not too low. And if there is the right opportunity, they would consider rejoining the workforce. So we believe that that would be of help to the overall labor market. Mr. Dennis Leung, Deputy Chair. Employers and employees are closely related. They have a sort of delicate relationship between themselves. It's just right that employees get employment protection, and employers should be well aware of their obligations in terms of employee benefits. Hong Kong is a society of a rule of law, and some employees told me that because of the transformation of the economy, they close up their business and they become employed by some other companies. But some employers have a very good conscience, and they wind up their business with good protection to their employees. So employers, instead of thinking about how to circumvent the law, should consider more how to improve their operation mode. And Hong Kong, like the rest of the world, is suffering from an economic downturn. And Xia Baolong, director, has asked us to be seeking changes in face of difficulties. So we should not be asking the government for help all the time. Employers should not ask the government to reduce employee benefits so that they themselves can stay afloat. Rather, they should spend more time to think about how to manage their costs, attract more customers, innovate in their business and operation so that their business can further improve. This is something that we should do instead. And in the past, we had 418 requirement. Some employers were trying to circumvent the law, and they are asking the employees to work for 17 hours per week for 4 consecutive weeks. So does the government have any figures on that front, i.e. the number of employees who are on non-continuous contract for a long time? And the government's paper said that 11,000 employees are to benefit in the future. Now, have you made an estimate on the number of employers who would be asking their employees to work for 16 hours in the future? Does the government have an estimate on such figures? And the law is very clear, but sometimes legal provisions are hard to understand. Going forward, will the Labour Department produce pamphlets and guidelines to set out clearly how the 4 weeks are being calculated? Because you have A and B scenarios. I hope that you come up with charts and tables to let the employers understand clearly how to make the calculation. And then the Labour Department should focus more on publicizing the employers' obligations. And only by doing that will you be able to help the 3 million workers in Hong Kong understand better their own rights and benefits. Who would take the question, please? The Assistant Commissioner, please. On figures, on the number of employers who willfully arrange for working hours which wouldn't for employees which would not be able to meet the continuous contract requirement. We don't have such figures. As to the number of cases handled by Labor Relations Division on that front, I would only say the number is very minimal. We really don't see employers deliberately getting around their obligations under continuous contract. As to the employers' behavior and employees' behaviors change upon the passing of the bill, well, we can't make an estimate. But I can say for sure that we will issue pamphlets and guidelines which will contain pictures and graphs to make the change more comprehensible for everyone. And we believe that publicity and promotion is of utmost importance. Some members refer to the fact that some workers now are even unaware of the 418 requirement. Now we are proposing this change. We will step up publicity.
Mr. Peter Chiu speaking for the second round. 3 minutes, please. Thank you, Madam Chair. Well, as said, I actually think there are employees only after there are employers. Well, they complement each other, I believe. Well, will all employers try to circumvent the new arrangement? I believe most businesses will want to enhance their competitiveness by lowering the cost of businesses. And it is only then that they will have clients and they will be able to survive. So most businesses will think how they can do better under the law. I asked a very simple question just now. Workers will not have to work 18 hours per week. Instead, employers will be able to use the aggregate working hours in 4 weeks as a counting unit. Will employees then get double benefits? I think the answer is in the affirmative. We have to think about why this current arrangement has existed for some 30 years now. If you work 8 hours within 2 days, and if you work like this every week, you can at most take up 2 jobs. And as said, if you already have a full-time job, you won't want to take up extra part-time jobs. Under the new arrangement, say you work 9 hours, as long as you work for 7.6 days. In the past, you would be deemed as a part-timer, but under the new arrangement, you will be a full-timer. You only have to work 7.6 days and 9 hours per day, then you'll be entitled to long service pay and annual leave. So workers may work for 3 companies, and as long as the worker works 23 days per month, the worker will be able to enjoy 7 to 14 days of annual leave per year. If that's the case, why would people still want to take up full-time jobs? You said full-timers, they earn more than part-timers. But if you look at the casual workers in the market now, they actually earn more than full-timers. With such an economic environment, you are implementing this policy. Well, all I can say is that there are many companies facing a very tough time now. They have been struggling. And like Mr. Dennis Leung said, these companies may fold. Well, this is a suggestion or a comment. You have heard the comment. What reply do you have? I have heard Mr. Xu. Well, some people may take up 3 part-time jobs, so theoretically speaking, they may be able to get 3 sets of annual leave. Well, but we have to look at how long their annual leave is. So even if you take up 3 part-time jobs, you may get 3 hours of annual leave only. This is a personal choice of employees. Under a continuous contract, if he takes up 3 part-time jobs, he will only get 1 annual leave because he is not able to meet the thresholds for all jobs. Also, the additional annual cost for businesses will go up by about $150 million. We have about 3.7 million workers in Hong Kong, and the additional cost only accounts for 0.02% of the annual cost for businesses. If you look at it this way, the administrative cost on the government side is even higher. I think it is worthwhile for employers to spend that money to retain their workers. Mr. Xu, say a worker does not take up a full-time job. Every day he gets 3 hours of annual leave. Is that what you're saying? A worker may work 4 hours in 2 jobs. So you only have that worker work for 4 hours. Is that what you're saying? I'm saying in the past, there's a full-timer and he gets annual leave of at most 14 days per year. Is that right? Under the new arrangement, say a part-timer meets the requirements, then the part-timer will also be entitled to annual leave. Would that be 7 to 14 days of annual leave per year as well, or just 3 hours per day like you said? Mr. Liang, I thank the member for the questions. To clarify, under the current employment ordinance, there is no distinction between part-timer or full-timer. As long as you work for 18 hours per week and for 4 continuous weeks, then you will meet the continuous contract requirement. For some people, they see this as a part-time engagement. However, they already meet the continuous contract requirement under the employment ordinance. Like those who work 40 hours per week, they are entitled to employment benefits as long as they meet the criteria like years of service and other conditions. Mr. Peter Xu said, for part-timers and casual workers, their hourly rate may be higher than that for a full-time employee, but the actual amount of pay they take home may be less than a full-timer. Well, Mr. Xu is not asking about the full-time pay. He's asking about annual leave. How are you calculating that? For annual leave, to be honest, even without the amendment, if we stick to the 418 requirement, a worker may work for 2 to 3 companies at the same time, as long as the worker meets the 418 requirement in each job, then the worker will be entitled to the employment benefits under the ordinance. Now on to the employment benefits. Take annual leave as an example. The worker will be able to get 1 full day of annual leave. Well, not 3 hours, right? Undersecretary said that, say the worker takes up a few jobs and for each job he only works 3 hours per day, and the so-called annual leave is equivalent to 3 hours of pay. It's not that you multiply the amount of pay by a certain number of annual leave. That means if he takes up 3 part-time jobs, he'll only get 3 hours of annual leave. Yes, you have to look at how much money the worker earns per day. Well, my logic is very simple. Say a worker works 5 days per week, then he works for a year and he gets 7 to 14 days of annual leave, right? Say if the worker works for 9 hours per day, as long as he works for 7.5 days, he'll be entitled to the employment benefits under the new arrangement. So if he works 23 days for 3 companies, then he'll be entitled to 3 sets of annual leaves. That is 3 times 14. That's over 30 days of annual leave a year. Will there be such situations? If this is allowed, then why would people work full-time jobs? Because as long as I do a few part-time jobs, I'll be entitled to some 30 days of annual leave. Well, the worker will still have the same level of income because the hourly rate of part-timers is higher than that for full-timers. Especially now that we have a shortage of manpower in Hong Kong. That's why we have so many people who like taking up casual jobs, because their hourly rate is higher than those who work full-time. Those who engage in full-time jobs because they get medical benefits as well as paid annual leave. But under the new arrangement, people will all switch to taking up part-time jobs. Any reply? We have spent quite a lot of time on this issue already. Now, a simple answer to this is that, say, a worker tries to get the benefits as much as possible. Say a worker receives annual leave from employer A, then he may have to take leave from employer B and employer C because he will have to take leave. So what will be the actual amount of annual leave this worker can enjoy? Madam Chair, under the 418 requirement, a worker may not be able to enjoy the leave, but now it is 468. He won't have to work so many hours, then he will be able to entitled to the extra leave. Any other members who would like to speak? Mr. Xu has spoken for 2 rounds already. Mr. Kwok Wai Keung asking to speak for the 2nd round, and Mr. Chao Xiu Chung as well. Mr. Xu, why don't you wait for a while? Mr. Kwok Wai Keung, 3 minutes, please. I thank Mr. Peter Xu for the questions. Mr. Peter Xu represents employers. He's saying that the economic environment now is not faring good, and he is expressing some strong opinions here, and this is understandable because the business environment has been quite tough. I have to stress a few points, however. The paper emphasizes that the relevant amendment for the labor market as well as the industry, the impact will be very minimal. About 11,000 people may benefit from the amendment, and the additional cost on businesses per year will go up by about $115 million. I'm talking about the entire market, not just one company. SMEs rarely hire part-timers. It is chained companies or large-scale enterprises that hire part-timers because of their work arrangement. So it's rather hard for SMEs to engage part-timers because it's hard for them to manage so many part-timers. Also, if it is like what Mr. Peter Xu said, that there are casual workers who will be entitled to double benefits, well, I have to first thank employers in advance for treating employees so well. Normally, pay is calculated on the basis of how many days you work. So if you work 3 jobs, you won't get a very high pay for each job, even if you get annual leaves from all 3 companies. or allowances from all three companies. Altogether, the benefits or allowances may be equivalent to that for one full-time job. So just want to dispel people's concerns about this. I think there's a very minimal chance that we will face such situations. Labor Department, anything to supplement? Thank you.
Mr. Chang Shu-chung, thank you, Chair. I'm also concerned about what I have spoken about earlier. Some employers now are arranging a schedule like this: 60, 60, 60, and 15. Does it mean that upon the revision, such a loophole can be plugged? And it's just like what I mentioned before, 72, 24, 23, 20, and then 0 on the 5th week. And you are asking the employee to work 139 hours. And that's not a very substantial change on the part of the employer. Will there be many cases in the future? According to the CNS Department statistics, 77% of such employees are working in that pattern. If we change it to 468 requirements, around 10,000 employees will benefit. For these 10,000 people, they are within the 7%. And then after the change, they will become employees on continuous contracts. Can the Labor Department continuously monitor these 10,000 people, whether they actually benefit? Or will it be the case that the revision is not good enough, and as a result, employees can still take advantage of the loophole? So would that be the case that those who are supposed to benefit will not benefit after all? Will you have a mechanism to monitor the situation? Can you elaborate on how you are going to monitor? Can I defer to the Labor Department, please? Thank you, Mr. Chow, for your follow-up question. At the Labor Relations Division, we will continuously, closely monitor the impact after the law is passed, whether there will be changes in the trends. Like I said, we rarely receive cases which stem from problems relating to continuous contract. Excuse me. You can't really look at these cases. For these cases, the employees will not go or approach the Labor Department. I think you should maybe conduct a survey or something to monitor the situation, to ascertain whether these 10,000 people can really benefit. While these 10,000 people are nothing but just an estimate. As to the ultimate number of beneficiaries and whether we have any methods to assess the number of people who will benefit, we will talk to the CNSD to see whether we can conduct an other thematic household survey to assess whether there are changes in the number of workers who are on continuous contract and those who are not. In previous similar surveys, we posed questions on employees, and we asked them, say, if they are on non-continuous contract, we asked them if there is a job which comes with longer working hours and meeting the requirements of continuous contract, would you opt to take up that job? Some still said that they are unwilling to take up the job for various reasons, personal some choices and things like that. But this will be one of the questions that we will be proposing, if resources permit, us to do another survey. Mr. Peter Shiu, third round. I'll be done after I ask this round. Many fellow members talked about 10,000 people, whether these people will be assisted. You are revising the law so that 4-week aggregate working hours will be used as a counting unit. I have talked about whether people who are full-timers will switch to part-time jobs so as to have double benefits. I'm worried that if people can really understand what I'm saying, then I am worried that there would not be just 10,000 people, but a lot more people. And people will be switching to part-time jobs, and as a result, the labor market will become tighter. Employers will think hard how to slash their operating costs and enhance their competitive edge and compete with others. This is understandable. And then employees have their own thinking as well. And if the law allows different options for them, they will think of different ways of maximizing the benefits. As someone coming from the business sector, I have to tell you what the business environment now is. You are just taking the perspective of the workers. You haven't considered that you would trigger or spark a lot of conflicts between the employers and employees. Now you are abolishing the offsetting mechanism for MPF, and I believe that a lot of labor disputes will arise. I don't need an answer. I'm just expressing my opinion. Thank you, Mr. Shiu, for your opinion. In the first 3 years upon the abolition of the offsetting mechanism of MPF, if there is a severance payment, well, we are allowing the offsetting only after 1st of May. The previous years of service before 1st of May cannot be offset. Starting from this year, 3 years onwards, and every year the employer will pay a maximum amount of only $3,000, with the remainder coming from the government. And thereafter, there will also be subsidies from the government. The subsidy will expire only 25 years later. Thank you. So I have to respond to that. I'm talking about the labor disputes. What I'm referring to is because for the 5% contributed by the employee and the employer are already locked, say, in the MPF, and for future amount to be dispersed, they are not within the MPF fund now, and this will spark labor disputes in the future. So what I'm referring to has nothing to do with what you just mentioned. Today we're not discussing MPF, so members, any further questions on the policies on this amendment exit? And members, do you think that we need to invite members of the public and the relevant organizations to give their views? No need, because the LAB has reached a consensus. Now we can go to the clause-by-clause scrutiny. Let's take a look first at the Chinese rendition. The revision is rather straightforward. Can the administration take us through the provisions, please? Mr. Mack? Chair? Members? There are 3 provisions involved, so I'll be going through them one by one. First is the long title. The title is this: amend the employment ordinance to lower the threshold in respect of weekly working hours that is used in ascertaining whether contracts of employment are continuous contracts. to introduce an alternative criterion for such an ascertainment that is based on the number of working hours in a specified 4-week period, and to provide for transitional arrangements. Clause 1, short title and commencement. This ordinance may be cited as the Employment Amendment and bracket Ordinance 2025. Clause 1, bracket 2. This ordinance comes into operation on the first Sunday after the expiry of 6 months after the day on which it is published in the Gazette. Clause 2. Employment Ordinance amended. That is the heading. And the content of the amendment is set out in Section 3. Members? Any questions on the long title and clauses 1 and 2? Any questions on the long title? Mr. Lam. The commencement date is 6 months upon the Gazetted. What is the consideration behind? The labor unions think it's not ideal, but then employers don't find it satisfactory either. Anyway, is the consensus reached by the LAB, and that consensus was reached early in the year last year, and that also went to the manpower panel. And now it's been more than 1 year, and you are still waiting for another 6 months before it commences operation. And some of the workers are not familiar with the relevant regulation or provision. So I would like to understand why it only commences operation 6 months later. What is the consideration? Who would take the question, please? Well, 2 points here. We spent some time in preparing the bill. Like what some members said, the revision may be rather straightforward, but it carries great significance. Well, using the analogy of a construction project, it's not simple renovation. We're actually changing the structural wall. So we have to be, looking through the whole ordinance. So we spent 1 year in doing that. Now, upon the passage of the bill, we will implement it in 6 months. Like what the members and the administration said, we have to mount an extensive publicity campaign. And like we said, 90% of our workers are now on continuous contracts. So for the remainder, we have to allow the SMEs to get prepared, and the employees have to understand it. And we have this option, an alternative provided on top of the 418 requirement in the past. We should allow sufficient time for the employees and employees to get prepared. And for some organizations, they may have to change their internal systems and so on. So we are suggesting the commencement date 6 months later. So no further comment on clauses 1 and 2 and long titles, and let's move on. Thank you. Now we come to clause 3. And that is to amend the first schedule of the EO relating to continuous employment. Clause 3, bracket 1. In first schedule, after paragraph 2, we propose to add a new section 2A. There are brackets 1 and 2. Bracket 1 sets whether a week is calculated as within the continuous contract week. And there are 2 criteria. Bracket 1, small letter a, bracket. the working hour threshold has been set at 17 hours or more. And to A bracket 1 bracket small letter B, if the week and the preceding 3 weeks amount to 60 hours or more, then those can be calculated towards defining the continuous contract. It sets the period of 3 weeks next preceding that week. Well, let me cite the scenario provided by Mr. Chow. It's long working hours here, so over 100 hours in that month. And this will not fall under the new definition of continuous contract. The reason being that during the period of 3 weeks next preceding that week. So this week is 0, and the preceding 3 weeks, 67 hours only, so it doesn't meet that with the definition. If you say it's the period of 3 weeks next preceding that week, or the period of 3 weeks following that week. Now, for the following 3 weeks, then it amounts to over 68 hours, so it can fall under the definition. I'm not good at mathematics. I wonder why you said it's the 3 weeks preceding that week and not the 3 weeks following that week. If you include the letter, I wonder whether you have made analysis, whether that would help plug the loopholes. Maybe you can resort to AI to make some calculations for you. And if you can't plug the loopholes much better, why don't you include that phrase as well? And if you think that there are still loopholes and the difference is not that great and the meaning is clear, then I will accept it. But I just would like to understand why you put the phrase the 3 weeks preceding that week.
Mr. Ma? I understand where the member is coming from. We want to have an amendment that allows more workers to meet the new requirement. As mentioned a number of times, if we are to draw a line, there must be people who fall under the line. What Mr. Lam is saying that we can include 3 weeks next preceding that week and following that week. We have considered different scenarios. Say a worker works less than 17 hours for 1 week. If we consider the 3 weeks preceding that week as well as following that week, there might be different outcomes because it will involve 7 weeks. 3 weeks before that week and 3 weeks after that week. There will be 4 different combinations as a result. So if we adopt this approach, there will be 4 different scenarios or combinations. And the worker may be able to fulfill or fail to fulfill the requirement, resulting in inconsistent outcomes. This sounds complicated, and in actual operation it may be even more complicated. Say, once a worker works less than 17 hours a week, we will have to adopt this approach, and there will be confusions as well as disputes. We have to ensure a scenario in which a consistent outcome can be derived, and we have to ensure that both employers and employees understand the calculation. So we have to look at the number of working hours preceding that week. That's why we are proposing this method. Madam Chair, I understand if we are to consider the 3 weeks following that week, it will involve a greater number of weeks and it will make the law more complicated. A higher cost would be incurred and a more complicated calculation method will be adopted. So I understand this. I am more concerned about those who work long hours. Say a worker only works 67 hours per month. Well, they won't encounter any problems. What I want to say is that I hope the government can study or learn about whether those who work over 100 hours per month can benefit from the new arrangement as well. I have a question. Women can benefit 14 weeks of maternity leave, and before that, the female worker has to work 40 weeks continuously for the same employer. So, will the provisions here apply in order for female workers to be entitled to the maternity leave? Yes. For an employer to be entitled to 14 weeks of maternity leave, the worker will have to have worked for 40 weeks continuously for the same employer under the continuous contract requirement. So the worker will have to fulfill the 2 criteria set out here. Any other questions? Well, please carry on. Now we've come to Clause 3, bracket 1. I've just covered the new section 2, capital letter A. Now I'm going to talk about section 2, capital letter A, bracket 2. It is a transitional provision. It sets out clearly that before the bill comes into operation and during the first 3 weeks immediately following the implementation of the ordinance, the employee may have worked for 18 hours or more in that week. The revisions mentioned in bracket 1, they will come into operation starting from the 4th week after the bill takes effect. Why is it the case? This is because we'll have to look at the working hours of employees during the 3 weeks before the implementation of the bill. If we do not introduce such a transitional arrangement, there may be confusions in legal claim cases. That's why the bill will only commence 3 weeks after. Any questions, Mr. Chow? I have a question. 3 weeks after the commencement date, say a worker has been working for 17 hours per week. The worker will not be meeting the continuous contract requirement. Is that right? Why 18 hours but not 17 hours, since the bill will have been passed already? After the bill is passed, the ordinance will come into operation 6 months after the bill is passed. So after the ordinance is implemented for 3 weeks, the workers will have to have worked for 18 hours or more per week. Just now, the member asked whether we can implement the 17-hour threshold earlier. If we implement this new threshold right after the ordinance comes into operation, well, first of all, it will be confusing if the two arrangements are implemented at the same time. Also, say a worker has been working 17 hours per week even before the commencement of the ordinance. Well, before the commencement, that worker will not be able to meet the new requirement. Well, we're supposed to look at the working hours for 4 weeks. If we implement the new threshold right after the ordinance comes into effect, then the worker will not be able to meet the new threshold under the agreed arrangement with the employer, because the old arrangement will still take effect. That's why we are implementing the new threshold only 3 weeks after the ordinance comes into effect. Well, I understand this. Do members have questions about this? Please carry on. Thank you. Clause 3, subclause 2. It's rather straightforward. It is to extract the part about 418 requirement. Instead, we're introducing the new requirement. As for the other provisions, they will remain unchanged. That's all from me on the bill. That's it. Any questions from members? Now let's look at the English version. Is the legal advisor looking at the English version? Thank you, Madam Chair. Please switch on the microphone for the legal advisor. Please switch on the microphone. Thank you, Madam Chair. On the English version, we did not spot any issues with any legal or drafting issues. So we've completed the clause-by-clause scrutiny. Will the administration propose any CSAs? How about members? No. If members have any CSAs, please propose them by 5 p.m. on the 23rd of May. If the administration have additional reply or comments on this bill, we will pass them on to members as soon as possible. We will talk to the Secretariat as well as the administration on when the second reading debates should be resumed. We will notify members on the date once we've settled that. Any other issues? All right, thank you.